Our people didn't look at land in the same way as people do today. I mean, we did not think in terms of straight lines. We did not think in terms of small plots. We did not think in terms of mortgages and deeds and titles. That was a different world that unfortunately we were required to begin to learn about. And prior to 1966, in spite of having been to high school in the lower 48 and spending a couple years in Fairbanks at the university and then finally graduating from George Washington University, it took me 5.5 years to get through college. Anyway, I still essentially did not have any grasp of Alaska Native history, anything about the politics surrounding the Indian tribes in the lower 48 and the legal provisions that related to them that had developed over a course of a couple of hundred years. And so when I came back from Washington, D.C., after I graduated there and started taking graduate courses, just by chance, Jay Rabinowitz, who was a member of the state Supreme Court, taught a small class in constitutional law. Well, I had associated with Indians. I used to be a volunteer at the National Congress of American Indians in Washington, D.C. I had attended some conventions of the NCAI. I had Indian friends. I still didn't get the full impact of their own history because it wasn't ours per se, directly, so we didn't understand it, and of course nobody taught it anywhere. So that paper I wrote for Judge Rabinowitz really was a revelation to me because this was 7 years after statehood. The mechanism set up in the Statehood Act had been in process, that is, the state was beginning to select lands. So what I did was I went back and you had to learn a little bit about international law because I used to be curious about what gave a European country or a foreign country the right to come to an already occupied land and stick up a flag and say, this we claim on behalf of our sovereign, the king or the queen or the czar. And so I read about that, and then I read about the Treaty of Cession. I wanted to know, what did the Russians think they owned in order to sell to the United States? What did the United States think it was buying? And what were the provisions dealing with Native people who were already here? And then I, of course, looked at some of the early case law that the United States had regarding the Indians and the constitutional provision on the federal government having plenary powers over Native Americans. And then I looked at some of the early laws like the Organic Act of 1884, which was passed for the new territory after the purchase, and other laws like the Indian Allotment Act that was passed for American Indians but then applied to Alaska in 1906. And then I looked at all the other laws that were relevant, that is the Citizenship Act of 1924, the Indian Reorganization Act of the 30s, the Indian Claims Commission Act of the 40s, and then finally the Statehood Act of 1959. Anyway, the long and the short of it was that I finally began to understand sort of the nature of our situation at that time, and we were in grave jeopardy because in looking at some of the case law, I saw where the underlying Indian title or native title or aboriginal title, whatever you call it, really could not just be assumed to have been extinguished. An extinguishment of native title created a compensable act under our law. And when I looked at the Statehood Act, I began to see that there was no actual extinguishment. They simply authorized the state to begin to select over 100 million acres, which in my mind was native land, that the state should not have had the right to select that land because there had not been an extinguishment. But I figured that the extinguishment would occur when the state made its selection and secured an interim conveyance, that is, a conveyance before the survey. And so I knew that if they got that interim conveyance, that IC, that we'd be dead in the water. That is, we'd never, ever get that land back. And that we might get some compensation, 50 or 100 years later, but we'd never get it back. And so I sort of got deathly sick about the notion because I could see that we were in grave jeopardy and that we had to take some kind of action to stop the selections, that were taking place. Because the idea was that, the state had a very, very small population, maybe 200 and some odd thousand at the time of statehood, with a big chunk of those being military and half the rest probably being under 15. And there was no private property because it had been a territory. I mean, very little private property because it had been a federal, territory. So with a miserable economy and a small population, almost no taxes, I mean, really the state, was barely functional. And of course the idea was that they were going to give them, the Congress was going to give the state all this land, native land, and they were going to live happily ever after on the leases and the revenues from the resources. Well, we threw a kink into that by the claims. Because we had to have take some action. Well, there was no provision for large claims. There were provisions for protest. That is, and of course it was sort of designed for the non-native world, really. Because we had had the Homestead Act on the books, and so if you were a homesteader, and the state came along and filed this claim for an interim conveyance that included your homestead, then you could file a protest, right? So you can protect your right. Well, there was no such right created in the Statehood Act for native claims. And of course, the non-native perception was to try to keep us to a spot and not to recognize the fact that our people use millions of acres in which to survive. And those millions of acres in earlier compensation cases was the way that they went about trying to determine not only the date of taking, but the value at the time of the taking based on traditional uses. So you'd have millions of acres at X, amount per acre. And then that was the basis of earlier compensation claims. And the mechanism by which Clinton-Haida got their settlement, which after 35 years, which was a small settlement of just over $7 million, but not a square inch of land, for the takings that were taken place by the Tongass forest withdrawals. Anyway, that to me was a big telling thing because I could see that the processes that were available for natives was completely inequitable. It was only based on compensation. There was no prospect of getting land, per se, under the earlier processes that had been in place and had been set up for lands that were taken from the native people in America. Anyway, so that paper really, to me, was a great revelation. And what it did, at least for me, was to clarify what was happening at that point in time. And when we formed the AFN the fall of '66, I did this paper in the spring. I think it was Charlie Edwardson or Ituk who had my paper printed and distributed to the attendees, which was fine because all my paper did was sort of confirm what Native people already felt anyway about the land. Because you can't live on a land for 10,000 years and not have actually people fought for their spaces, right? And so that little paper helped clarify for us what some of the history and what some of the law was.